tomorrow, March 3rd of 2025, there's going to be a case going forth before the 10th District called Kurtz case. And the Kurtz case deals with facts that are very similar to those in Dillon, which was decided by the Ohio State recently, or Ohio Supreme Court recently this year, 2025. And just a quick explanation of Dillon, and this deals with what happens with your compensation, or what happens when you're found to be MMI at an industrial commission hearing. So before Dillon, if you were determined by the Ohio Industrial Commission at a hearing to have reached max medical improvement, relying upon the medical opinion of a doctor, then and the hearing officer relied upon that and said, yes, you are MMI, then the date of the hearing, your comp would be cut off, and that would be the date that you would be found MMI. So you'd be found MMI as of the date of the hearing, not as of the earlier date of the IME's examination, or independent medical evaluation examination. And therefore, there would be no overpayment, theoretically. So, and what the Ohio Supreme Court said in Dillon is that essentially what the hearing officer, if they relied upon an earlier independent medical evaluation by a medical expert, or a medical expert's opinion that said, hey, this individual has reached max medical improvement for their allowed physical conditions in their claim. If the hearing officer relied upon that earlier IME report, then, well, one, your comp would be cut off as of the day of the hearing, but two, there would be an overpayment because you would have, in fact, not have been entitled to temporary total disability because you'd been found MMI as of the date of the independent medical evaluation's medical exam. So what does that mean for you? How does that work in theory? So if you're examined by an independent medical evaluation, a doctor, a medical doctor, on March 1st, and then your industrial commission hearing was on April 1st, then, and if that industrial commission, that district hearing officer said, yes, I'm relying upon that doctor's exam on March 1st, that this person was MMI as of that date, then you would be declared to have been MMI as of the date of March 1st. So on April 1st, the date of the hearing, your comp would be cut off, and then you would have an overpayment from March 1st to April 1st. And then eventually the BWC would recover that. So this is essentially what's at stake at this 10th District hearing or argument tomorrow before the 10th District as to whether or not that's a correct interpretation of Ohio law and statute. And we'll see, and it will impact you, the injured worker. So